Good afternoon, Daniel Bornstein, Bornstein Law. I am so pleased that you have decided to join me in educating you about the rigorous rules involved with landlord-tenant law in California as we involve ourselves, unfortunately, with the continuation of the COVID-19 pandemic. Most importantly, you should congratulate yourself because you've made the commitment to learn what is admittedly a very, very cumbersome and challenging time in all of our lives. And landlord tenant law has become even more complex with the emergence of SB 91, which just came into effect less than 30 days ago or 35, 40 days ago. And it's a 54-page statute. Buckle up, get ready, and let's begin. So I'm going to be going over the updates on COVID, and the agenda will be as follows. I'm going to talk about SB 91, which is really the extension of what we have already been under as it relates to landlord-tenant law and non-payment of rent, especially COVID-related rent, with a couple new nuances that are very, very attractive for owners. I'll be discussing COVID rent debt and where we can access government resources to cover some of the COVID rent debt that has accrued. I'll touch upon tenancy terminations, rent increases, eviction moratoriums that are occurring throughout the Bay Area, and talk about the interrelationship between the state law and local law. And then, as always, I'll talk about negotiating voluntary agreements with tenants to obviate the need to get involved with the court. So with that dialogue, we will proceed. Let's start. Initially, we had AB 80. SB 91 extended the COVID rent relief to June 30th, 2021, which means, in essence, your ability to collect all of your rent that's due and owing, and if not, proceed with an eviction action is not permissible at this time for most all of you. The general rule is as follows. For debt that accrued as of March or April of last year through and including March of this year, if a tenant has paid 25% of that monthly rent debt and asserts that they are impacted by COVID in a COVID disclosure, that's what you're going to be able to collect. And the balance of that 75% will be something that you can collect through small claims court. You won't be able to evict. Now, this new law extended this all the way through June 30th, 2021. What does that mean? That right now, if you have a tenant who is impacted by COVID and they pay 25% of the rent, you're not going to be able to pursue an eviction against them for non-payment of rent. That's the general rule. What happens with the 75% of the remaining balance? It is going to be collected through a small claims court judgment under the new law. However, there are some nuances, and I want to go through it because the nuances are what is most compelling for this discussion today. This new ordinance also preempts local jurisdictions from changing rules that were in place after August 19th, 2020. So we're not going to see new local rules that impact the COVID rent debt rules that have been put in place under SB 91. The big ticket item, which is why I wanted you to be here today, is that there is now $2.6 billion available in California for owners and landlords to recoup COVID-related rent debt that is owed to you by tenants through state funds. The public policy of SB 91 is for all of us to focus on trying to recover unpaid COVID rent debt through the state. And we're going to talk about how to do that. Before we turn the page, I want to emphasize a couple things. I've been practicing law for 25 years. Normally, in the last pre-pandemic, people would call me up and say, Mr. Bornstein, someone owes me $5,000, someone owes me $3,000 in unpaid rent, someone owes me $2,400 in unpaid rent. Once a year, I'd have someone tell me, hey, Mr. Bornstein, a tenant owes me $24,000 in unpaid rent. And I'd be thinking in my head, where have you been sleeping? Why so much debt? Well, interestingly and unfortunately, during the COVID-19 pandemic, many of you have been contacting me and telling me, Mr. Bornstein, I have a tenant who hasn't paid me since April 2020, and they now owe me $33,000. I have $24,000 in unpaid rent. I have $18,000 in unpaid rent. I have accruing rent debt, and I have no hope of ever recovering this debt. Well, I agree. It has been a traumatic time period for many of us as we look at COVID time period and are wondering where the light at the end of the tunnel is, when the pandemic is going to cease, and how am I ever going to cover this COVID-related rent debt? Well, the good news is SB 91, though it elongated the time period for tenant protections, it has created a pool of wealth available to owners to recoup rent debt. And let's proceed and discuss how. Notice, the most important thing between now and March 1st is that all of you who have tenants who are experiencing and have not paid COVID-related rent or only paid partially COVID-related rent from April of last year through and including the present, you need to serve a notice of this type. It must be served before the end of this month, and the document that's in front of you is a document that's available by my office, and I will be glad to send you the document so that you can prepare it and send it to your tenants. If you've got 4 tenants in a unit, then please make sure you list 4 people on that notice. If you've got 2 people get the form. How do you serve the document? The way you serve the document is that you mail it. Mail serve is effective for this notice. Now, the California Apartment Association has their own form. Other organizations will have their own form. As long as you've got a quality form that articulates notice requirements to a tenant, and you send this out before the end of the month, you're fine. What you're trying to do is notify the tenants of their rights. And if you look at the second portion of this notice, the third last paragraph informs the tenant that you may qualify for rental assistance and informs them of this state program that's available to them. And that's important. That's what you're required to do. For any of you who have tenants who have not paid a full amount of the rent from March of last year through and including the present, I want you to make sure you get this notice served. You don't have that much time at this juncture. So please, this is a core requirement. Email me and I will email you a template of this document in Word format, and you need to mail it. If you're concerned that your tenant will not claim they received it, then post the notices on the door and also mail it. Of course, you can serve it by personal service as well. If you post it on the door, I want you to take a photo of it. If you mail it only, I want you to take a photo of the envelope. I want you to complete a proof of service proving that you served it for your records. We want to make sure you're code compliant with this document. If you haven't done it, get it done before the end of this week so that you are compliant and have done the first threshold showing to ensure that you have completed this aspect of your requirements so that you can qualify for potentially recovering COVID-related rent debt from the state. Let's move on. Let's talk about the program. This program will require an application that you will need to complete. The applications are not available yet. So many of you are calling me and saying, Mr. Bornstein, what do? I sent out the notice before the end of February. When am I about to get the information so I can apply? And the answer is, we don't have the applications yet. I don't know yet, but I'm monitoring it. And rest assured, if you follow me on social media, if you follow me on Facebook, if you follow me on LinkedIn, I will let you know when these applications are available. They're going to be local applications. My understanding in San Francisco is that the Mayor's Office of Community Development and Housing is going to be responsible for the rental payment program for landlords with property in San Francisco. The applications are not going to be accepted until March 15, 2021. So right now we're just in a holding period. The infrastructure of the program has not been set up such that I don't have the documentation to send you regarding the applications. The good news is you don't have to solely rely on your resident to submit the documentation. You can apply for the state rental assistance program on behalf of your resident. However, your resident or tenant who owes COVID-related debt is going to have to complete some of the information in order for you to receive those funds. The good news also is not only can you be proactive and submit the documentation with the cooperation of your resident, the money goes directly to you. It doesn't go to the tenant. That will allow you to ensure that you recover some of this rent debt that has accrued. I will tell you once again, the public policy behind SB 91 is to allow people who have an abundance of rent debt to seek relief from the state, not to go to court and file an eviction action. The whole goal is to stabilize tenancies, not to disrupt tenancies during the pandemic. I know we're trending positive right now with reduced infection rates, the vaccine, reduced hospitalizations, but we're still in the thick of it. I believe the light is at the end of the tunnel. One light for us right now is that rather than relying on tenants to pay the debt that they owe, we may be able to recover and recoup this money from the state. I will get you the documents when I learn of them, or will inform you of it, but you've got to stay informed. Within the next 21 days, I believe you're going to have those applications available and you're going to have to submit them. My hope for my group of people here is that we are first in line, because my expectation is first in line, first to get paid. And if you're late submitting the documentation, who knows? This is all new uncharted territory. And my goal is to educate you so you're ready to go and starting to collect the information necessary. You've got your notice sent out before the end of before the end of February. And now I believe that even if you have differences with your existing tenants, if they owe you rent debt, you've got to now reach out to them, have a communication with them, and let them know about a win-win situation where their debt can be alleviated by cooperating with you to seek rental assistance through the state. Now, it's ideal to seek rental assistance from the state, but it's not for everyone. your tenants in their household, whether it's a one-member household, a three-person household, a four-person household, must meet the following criteria in order to be eligible to recover state rent debt payment for you. Here are the bullet points. At least one person in the household either qualifies for unemployment benefits or has experienced reduction in household income, incurred significant costs, or experienced financial hardship. Now, again, we don't know what the forms look like. We don't know whether the tenant is going to have to provide documentation or simply sign a statement under penalty of perjury. It remains to be seen, but these are the criteria, and all of them have to be met. In addition, at least one person in the household has to demonstrate a risk of experiencing homelessness or housing instability. For example, a past due utility invoice, an unpaid rent notice, or a 15-day eviction notice will likely suffice. If you haven't sent your tenant a notice about their unpaid rent, I think you should do it. It doesn't have to be that 15-day notice. It can simply be a letter to them. Dear John, be advised, you have a rent debt accumulating through the end of February in the amount of this. You want to let them know that they've got an unpaid rent debt. Some of the other criteria is unsafe or unhealthy living conditions or any other evidence of risk of experiencing homelessness or housing instability. But I will tell you that we don't know what the document is going to look like. These are the bullet points. And in order for you to qualify to recoup COVID rent debt, your tenant, one member in the household, has to meet all of these criteria. My expectation is going to be a signed document by the tenant, maybe with additional documentation attached, but it's going to have to be signed by the tenant. You're going to submit it with your request, and then you will hope that the funds are available for you from the state. I want to emphasize, even though a tenant may meet the eligibility, may satisfy all of the criteria, it does not guarantee rental assistance funding. The program allows for prioritizing housing where we have households that have less than 50% of the area median income, than to households with incomes less than 80%. One threshold requirement is that your group of households must make less than 80% of the median income for that community. If they make more, if they're actively employed, if they've not identified any sort of housing insecurity, but they simply on their own determination decided not to pay you during the COVID period, you may not qualify, and we'll deal with that later. The most important thing is in this time period, you focus on seeing if you can get the documentation together when the applications are available and submit it, because the goal would be to recover the money from the state as opposed to chasing a tenant for debt that they may not have. The one thing I want you to understand with the state is that in exchange for you participating in this state rental assistance program, the only amount of total debt that you can collect from the state is 80% of the unpaid rental debt that has accumulated from April 1st through and including March 31st, 2021. So if your tenant owes you $10,000 right now, if you choose to participate in the state rental assistance program, the most you can get from the state is $8,000. The other $2,000 gets washed away. That is the compromise that you're facing. I believe that in my mind, it's more than prudent for you folks to try and get 80 cents on the dollar of debt, then choose to proceed against a tenant in a different mode at this juncture. So right now, the chronology would be send out the notice before the end of February that I referenced, stay informed of when these applications are going to come out and start to talk to your tenants about, look, we may have our differences, but right now we share a common win-win situation. If you cooperate with me, I'm going to apply for COVID rent relief from the state. And if I end up securing that rent relief, your debt is washed away. Let me say that again. A tenant's debt will be washed away for that period of time if you've recovered the funds from the state. So it's in the tenant's interest to cooperate as well as your interest, because if you do the math, hiring an attorney to proceed against a tenant for debt and the time, energy, and cost will certainly cost you more money than 20% of the debt typically. So I believe, and I'm a strong proponent, is let's try to stay laser focused on trying to get you recouped your rent debt through the state, at least between now and through the end of March, to see what's going to happen. Hopefully the program works itself well and my clients are happy knowing that they've recovered 80 cents on the dollar of the debt that they have been owed. What happens to the unpaid rent debt accumulated from April 1st to March 31st that is not paid by the state? Under the program, if you've accepted it, you cannot proceed with an unlawful detainer action. You cannot proceed with an eviction. That's the compromise. By taking the benefit of state money, you're stabilizing that tenancy, and you will not be able to proceed with an unlawful detainer action. But then again, if you've recovered 80 cents on the dollar during the pandemic, you haven't done too terrible in light of what's out there and what many of my clients are experiencing. Do you have to accept rental assistance provided by the state? I think you do, and I think you should. There is an existing law in California that you cannot discriminate against a tenant's source of income, and this rent assistance program can be characterized as tenant income. I know that's strange, but if a tenant is able to qualify and meets the criteria, you should participate. If you don't want to participate and you don't want to actively seek an application on behalf of your tenant, the tenant can seek it, but then you're only going to be entitled to 25% of the debt as opposed to 80% of the debt. And that's why, in my mind, it's so much more prudent for all of you to start looking at your tenant profiles. If you're a property management company, get your portfolio together and look at the list of tenants who are carrying tenant COVID debt. Make sure your notices are out by the end of February, and then start calling or communicating with tenants that you are going to participate in this program, and you eagerly welcome and expect their cooperation, because if they cooperate, their debt will be eliminated and you will be compensated 80% of the debt. The big caveat is we don't know if your tenants meet the criteria yet, and we don't know how much money is going to be out there for everybody, because it will depend upon how deluge the state is with applications. I hope corruption doesn't infect this program. Most importantly for all of you, I think between now and the 15th, you really want to get organized and try to recover this money from the state. This is the first time in 25 years of practicing law that the state is creating a huge pool of wealth for landlords to tap into, arising from debt that was created by a tenant's inability to pay it. I want you to also know utility arrearages will also be eligible to be paid, but it's subject to funding availability. And we right now do not know whether there are going to be sufficient funds available to actually provide coverage for those people who cannot pay their utility bills. The state is going to directly administer the program. However, individual locations and communities throughout the state are going to be the ones that are going to be tasked with providing the rental payments for individual communities. San Francisco, my understanding, it's the mayor's office of community development and housing. We're going to find out the patchwork as it evolves and provide that information to you. I fully expect the news to be broadcast through all the different trade industry groups, whether it's the National Apartment Association, the Small Property Owners Association of San Francisco, the Professional Property Managers Association, the San Francisco Apartment Association, the Berkeley Small Property Owners Association, the East Bay Rental Housing Association. Just stay informed. I am also going to be one who will be providing that information. It's crucial that you stay informed. I want you to also understand this. If you don't participate in the program and decide you're not going to participate, and then you proceed in court to seek a monetary judgment against a tenant, and they show you refuse to participate in this program, you can be limited in your damages. SB 91 prohibits late fees on COVID-19 rent debt until June 30th, 2021. I know your lease agreements. They're wonderful. They all have late fee provisions. Remember, you can't assess a late fee on COVID-related rent debt from now through June 30th and going back all the way in time from March 2020 through and including June 30th, 2021. Also, where a tenant is making a current payment for rent, their check is delivered to you and it says February 2021 rent, you are not entitled to take that check and apply it backwards to COVID debt that arose in the summer. You apply it to February rent debt. The tenant still has summer COVID related rent debt, and that summer COVID related rent debt, go and seek those funds from the state. I want you to be careful about this. You've got to understand no late fees and no applying payments backwards at this time. Again, there is a limitation on public disclosure of eviction cases involving non-payment of rent between March 4th, 2020 and June 30th, 2021. And in fact, you're not even allowed to make a determination if you're looking at tenants for potential new applications for rental. You're not allowed to consider rent debt that arose during the COVID period in evaluating who you are going to select as a tenant or not. Very interesting. We're trying to insulate tenants from the negative consequences of COVID-related rent debt throughout all aspects of their tenancy, stabilizing their tenancy, not publicizing that they may have been subject to an eviction, and also not making an evaluation of a tenant for selection of a new rental opportunity because they had a COVID-related rent debt. Also, you're not allowed to assign or sell the rent debt to third-party debt collectors. That means that if you have COVID-related rent debt, again, the policy is to seek it from the state and hope that your tenant qualifies, meets all the criteria, and you get 80 cents on the dollar. Evictions under COVID-19 Tenant Relief Act. So now let's assume that you did not participate in the state rental assistance program. Your tenant did not qualify for it because your tenant did not meet the criteria. What are the rules? Well, prior to the pandemic, we had 3-day notices to pay rent or quit. During the pandemic, from AB 80 to this SB 91, we now serve a 15-day notice to pay rent or quit. The 15-day notice must include a declaration that a tenant can sign claiming a COVID-related hardship. And here's the rule. If a tenant owes you, let's say, $1,000 for April 2021 rent, and you serve them a 15-day notice, and the tenant files and fills out a form saying they are adversely affected because of COVID, then they have until the end of June to pay 25% of that February missed rent payment. So if the rent was $1,000 and you served a 15-day notice for February or March rent debt, and the tenant filled out the form and then paid $250 at the end of June, you will not be able to evict. Instead, the remaining balance of $750 can be sought in small claims court for a judgment. You won't be able to evict. And so for right now, all of you who are getting potentially excited about non-payment of rent tenancy terminations, what you're really looking at is serving a notice with a COVID hardship, expecting a tenant to fill out the hardship, and then you're basically waiting until June to see if they've come up with 25 cents on the dollar of the debt. And if they do, then you got to wait until August to file a small claims court action. And if they don't, then you can file the lawsuit. As of July 1st, we're back to pre-pandemic rules for most of us, with the expectation of receiving the full 100% of the rent when due. However, I've just made a comment about July 1st. I want you to know that there's no prohibition against Sacramento extending these prohibitions for another 6 months. Let's see where we are in what stage of the pandemic, whether we're further trending positive or not. So everything is fluid. My job is to educate you and recognize that you need to stay informed because the rules are changing and they may change again. My hope is this is the last go around, and come July, we have greater clarity about what the expectations are between landlords and tenants. I want you to know that AB 91 also extended just cause eviction protections under the new state just cause eviction rules to all tenants throughout the state until June 30th, 2021. That includes single family homes and condominium units who typically under 1482 were exempt. What does this mean for you? The expiration of a fixed term lease is not a just cause to evict. So if you have a tenant whose lease is expiring in a single family home in Walnut Creek come April of this year, if they don't move out, you can't file a lawsuit because they now are under just cause eviction protections until June of 2021. There are some exceptions to this rule, but generally the public policy has been to try to preclude people from seeking recovery of possession of premises and going forward with evictions during the pandemic, because we're trying to stabilize housing and not cause people to lose housing. So with this extension of just cause protections under the state, you really do have to recognize that what we're trying to do is at least through the end of June, keep people in the housing, try to recover debt through the state. And unless you have tenants engaged in egregious conduct, such as vandalism, drug dealing, violence, arson, you really don't want to get involved with a lawsuit at the county court. You really don't want to get involved with a lawsuit with the county court. One of the reasons being is the courts are slow right now. The courts have difficulty scheduling things right now. Impaneling a jury is a tremendous time consumption. Cases that don't get settled now are being continued until July. I want you to know that I build my family off of your work with me, and litigation and lawsuits help feed my family. However, rest assured right now, I'm not interested at all in pursuing eviction matters unless we're dealing with egregious situations, because what you will find is that the delay in the court and the new rules are such that everything is against you. For violence, for drug dealing, arson, for things like that, of course, the court is still open. But for other matters, it's a delayed and struggle. So avoid it until the court is more properly functioning. That's my bit of advice. There are some exceptions to this rule, And one of the big ones is if a seller is selling a property and is in contract and there is a tenant, you can serve a termination notice. That is one of the exemptions. But rest assured, the optics of evictions during the pandemic are less than ideal, of course. And so we try to avoid them. We try to focus on trying to mitigate disturbances by communication and compromise, not by aggressive landlord conduct through the use of the court, because the court is not functioning well at this time. Sheriff's evictions are sketchy. Some places are not evicting right now. San Francisco requires a special order by the court to allow an eviction to go on. So I have clients who have judgments against tenants. We have the writ with the sheriff, but the sheriff is not executing the eviction at this time. So I would hate for you to go through this whole process and be in a state of suspended ambiguity because of COVID-19, but that unfortunately is where we are at this juncture. I mentioned to you that any rent debt that accrued between March 1st and June 30th will not be a grounds for an eviction if the tenant has filed a COVID hardship, paid 25% of the unpaid rent. The remaining 75% balance will be converted into consumer debt. And what that means is it's not evictable. You can get a judgment against the tenant for the unpaid rent, and then you can use that judgment to collect, whether it's wage garnishment, filing an abstract of judgment on at the recorder's office, but you're not going to be able to evict. I want you to remember that small claims court is only open for COVID-related rent debt beginning August 1st, 2021. So the jurisdiction also has been expanded to recover debt in excess of $10,000. Normally, small claims court has a jurisdictional limit of $10,000. Because of the COVID pandemic, they've lifted that limit to be larger than that. So for example, if you have a tenant who does not qualify for state rental relief, the tenant has paid you 25% of the rent debt, but owes you at the end of June $25,000. They filled out the COVID hardship. The tenant remains in possession. You can't evict for that debt, but come August 1st, you can file a small claims action for $25,000 in small claims court. Now, it's up to you to decide whether you want to proceed in small claims court without attorney representation, or whether the debt is large enough, $25,000, that you want to file in regular civil court, whether it's limited jurisdiction or unlimited jurisdiction. You will have the right to attorney representation. Let me go back for a second. Another point regarding small claims. Remember, if you file a small claims court hearing, the judge could be a volunteer attorney. The process of a small claims court case may be something that you're surprisingly very disappointed with. The decision doesn't guarantee you get a judgment. And also, interestingly, for small claims, if you as a plaintiff file a small claims court case against a tenant for COVID-related debt, the 75% that hadn't been paid, and you get a judgment in small claims court for that $25,000, a tenant has the right to appeal that judgment, an automatic right to appeal it, and then it's not an appeal, it's a trial de novo, a new trial in small claims court, and at that point in time, both parties can be represented by an attorney. But that's only a right of a defendant. If you are a plaintiff in small claims court and you go after COVID-related rent debt and you don't recover because of alleged habitability issues, and you lose the small claims court, you can't appeal. You're done. So the right of appeal and the right of a trial de novo is a right that a defendant has, not what a plaintiff has. So even though small claims court is an available remedy for those of you with COVID-related rent debt, think twice before you proceed in small claims court, I am always happy and ready to discuss strategy with you. Again, oftentimes only in retrospect will we know whether a decision was made prudently or not, but I'm happy to game out decision making for you so that you can maximize the highest and best recovery and reducing the risk of potentially a case that goes south. With that, I want to talk about evictions. So I have told you that SB 91 has stated that you can't have new rules regarding COVID-related rent debt. But I want you to know that there currently are moratoriums in place in different jurisdictions throughout the Bay Area. Alameda County has a moratorium. The big one exception in Alameda County for evictions are health and safety. What are they? Again, drug dealing, vandalism, violence, arson, that type of matter. Contra Costa had a moratorium. Individual cities had a moratorium as well. I have emphasized that I want you to think strategically before you decide to pursue an eviction, because you may get tethered into a situation where there may be the continuation of a moratorium. And I want you to know there's a whole slew of landlord attorneys who are communicating by email, and we are astonished by the way in which the court is interpreting the law and making it difficult to proceed with eviction actions during this period of time. Be careful. A sublet violation where a tenant has sublet a unit in contravention of the law and you want to enforce your lease agreement right now, I would tell you you're better off maybe thinking about how to manage that sublet situation than pursuing that breach of lease in court, because you may not get anywhere with it. San Francisco has a moratorium, of course, as well. San Francisco is both a state and a city, and I can only tell you that I have been very, very conservative with my clients, informing them that I think we ought to wait before we proceed, because the inertia, the delay, and these local moratoriums can create havoc with the ability to proceed. Not to mention, if you do get a courtroom, the judge is apprehensive to try to proceed with the case because of shelter in place considerations, jury selection, and much of the work will be done on Zoom, and Zoom meetings are not an ideal place to litigate cases. So with that stated, I wanted to let you know that I have always talked to you about negotiating voluntary agreements where a tenant voluntarily vacates in exchange for something like a waiver of rent. I've always told you that it's preferred to get a vacancy voluntarily than to proceed in court. I still stand by that proposition. However, I want you to understand one thing right now. For those clients who have vacancies in their units and they are left with COVID rent debt but a vacant unit because a tenant moved out, you're not going to be able to recover rent debt with a vacant unit through the state. So right now, if you have tenants who owe you rent debt, instead of pursuing a move out, you may first try to get your rent debt recovered from the state. And if they qualify, get that 80 cents on the dollar. And only after they qualify on 80 cents of the dollar, when we're dealing with April, May, June, July, that future rent debt, then and that debt, I would consider dialoguing with the tenant about voluntarily vacating in exchange for some sort of remuneration, either a small payment, a rent waiver, the return of the security deposit, or a combination of them. I want you to remember, though, different jurisdictions have different rules regarding buyout agreements. For those of you who are in Berkeley, Oakland, San Francisco, you need to follow the local rules. If you don't know the local rules, email me. I'll send you the packet and help you out. But for right now, if you've got COVID rent debt, I may delay the discussion of a voluntary move out until I see if I can get those funds from the state. Now, some of you are sitting there, and I want to say this. We've had 500 people attend this webinar, and I want to say it's a reflection of why it's so critical right now to stay informed, because the laws are confusing and it's the largest group of participants in a webinar that I've had to date. And it's a reflection of the laws keep changing, and people need to understand the best approach right now is stay informed and try to get that rent debt paid by the state. After March, there is no indication that the state is going to cover April 2021 rent debt, May 2021 rent debt, or June 2021 rent debt. So you're on your own regarding that. Tenant, again, as we discussed, is entitled to pay 25 cents on the dollar, and they have until the end of June to make that payment, as long as they fill out the hardship form, which we anticipate they will. I remain available to help you out. I am a big proponent of buyout agreements, right time, right place. If you have tenants who are willing to leave and you don't want to chase them for a COVID debt, negotiate. I know that rents have contracted and that vacancy rates are higher. I do think they're trending a bit more positive, that many property management companies have large vacancy rates. I'd rather keep a tenant in a unit, negotiate a bit of a rent reduction, doing it correctly, than losing a tenant over what they perceive to be too high of a rent. I am happy to counsel you regarding that. Most importantly, I'm available for you, and follow me. I want you to know, as I've mentioned, this is a very fluid situation. If the California strain emerges to be more deadly and more rapidly occurring, we may have an extension of this. We may be in through June, be in through December with this. The laws may change. I'm committed to educating you. It's something I'm very proud of doing. It's a lot of work, and I have to remember that this team of people who are working with me to help these webinars, whether it's within my office, outside of my office, they're wonderful. I can come here and talk, but the process of bringing this to your attention, preparing the slides, making sure that you're informed of the webinar and organizing it is a whole team effort. I want to thank each and every one of them. And I want to also thank you for staying informed. Let's not make a mistake. Let's stay healthy. Please, I'm going to post this webinar on YouTube. I'm going to also continue to send you information, and I want you to not be shy. If you have a question, you need assistance, email me. If I need a half-hour meeting with you, I'll let you know. If you just need a document such as that notice, email me. I'll send it out to you. The goal is that you're well prepared to do well with your investment. You're making good decisions. You're informed, and you have the information available so you do not put yourself in a situation of jeopardizing or facing yourself with unnecessary tenant litigation or demands. Most importantly, again, thank you for being attentive. Daniel Bornstein, I am always happy to be a conduit for good decision making, and I, again, thank you. Follow me on Twitter, Facebook, LinkedIn. We will provide you additional information so that you keep abreast of things between now and March 15th. It's a critical time to stay informed. I want to hear beautiful stories of you folks collecting 80% of the rent debt from the state, because that is going to be something that's easier than chasing a tenant for those funds. With that said, I want to thank everybody for your attention. And once again, emphasize, please be safe, get yourself vaccinated, and let's live through this pandemic in a manner that we can all be proud of and look back with a sense of relief when it's behind us.